Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book from Oxford University Press, and this is an important book, certainly relevant to a wide group of lawyers. The title of the book is Civil Jurisdiction and Judgments in Europe: the Brussels I Regulation, the Lugano Convention and the Hague Choice of Court Convention. And it's been written by Trevor Hartley, and it comes to us from OUP's Oxford Private International Law series. And I'm very grateful to Trevor for producing it. This is an important book at a difficult time for us in the United Kingdom as we prepare to leave our membership of the European Union. Now, Elizabeth and I have given the title of our book review the following: Whether pre or post-Brexit, this new and authoritative approach to three key instruments of European legislation remains essential reading. And that's exactly what it does do. Here's the book, first of all. It's a hardback. There we go. Dark blue cover. There's the front of it, you can see. There's the spine. There's nothing on the back. Spine there. Now, the book itself is quite a hefty one. It's very much the house style for OUP. It's 560 odd pages. The index at the back is by reference numbering, not page numbering, but by reference numbering. So you can see immediately that you've got to know how to get your way around the index itself there. There's also a relatively short select bibliography, which again will have all the usual suspects in it. I remember from my bar school days having to deal with civil jurisdiction and judgments, and did find it a bit confusing. It was the old Supreme Court white book in those days, and it was a little bit difficult to follow. But this book is, I think, very helpful. That's the series of publications from OUP's Private International Law series there. Then you've got the front page itself. You've also got some detail about OUP there. Then you've got the preface. Always read the preface for these books because it does tell you what it's about. Preface dated the 1st of January 2017, and that's when the law is as stated by Mr. Hartley. Then there's a general editor's preface about the series, and his name is James Fawcett, and he's just explaining effectively what this book is about and where it's come from. Then you've got the table of contents itself, and you see how it's structured. It's in various parts and various chapters, and then you've got a large number running all the way through. You can see as I'm running it, we're up to part 4 there. There we go. Now, the total number of chapters are 25. Then after that, you've got 11 appendices, all listed there. You can see you've got, and then the bibliography. Then you've got the case law, of course, a large amount of case law, again. And after that, this is numerical. It starts off being, in fact, the way it's done is alphabetical initially, then it becomes numerical. Mainly because it's the way in which the cases are actually cited. That's why they've done it in this particular way. Then there's another way of setting it out. The national case is there as well included. You can see that. Those are the non-CJEU cases. Then you've got the legislative instruments, as they are called for this book, which again covers a wide range of things, treaties, articles and so forth. Then you have a very useful list of abbreviations, which I've always found very helpful with anything European, because there's an awful lot to take in, and sometimes it really is quite difficult to follow some of the things that are being said. So it's useful to get some idea, for instance, of what the abbreviations are. You can see that. Then we get to the specific parts of the book. Part 1. Then you've got the chapter. You've got a short index for the chapter. So you should be able to find what you're looking for pretty quickly. And then you, as I say, you have paragraph numbering and footnoting. And that's the way it runs all the way through the book. And you just take it in the middle, you can see that's the tort law there, special jurisdictions and so forth. And then going on from there, choice of court agreements, for instance, are covered as well. There we go, a very good book by Trevor Hartley. Well, what do Elizabeth and I say about the book? make sure it's just standing up properly so you can see it. There we go. Well, we say this, that Brexit or no Brexit, civil jurisdiction and Judgments in Europe by Trevor Hartley, just published by OUP, is an important book, and we think it will remain so. The point is driven home succinctly, yet forcefully, by James Fawcett in the general editor's preface, when we're reminded here for a moment that the stated aim of the Oxford Private International Law series, which is what this is part of, is to publish high quality and original works in a number of areas of private international law, and this is one of them. Now, Trevor Hartley has already contributed a monograph to the same series entitled Choice of Court Agreements under the European and International Instruments. This is the latest title of over 600 pages, which goes much further, examining in depth and in detail the three instruments under scrutiny, namely, as it says on the title page, Brussels I, the regulation, the Lugano Convention, and the Hague Choice of Court Convention. And these instruments, says Hartley, have a feature in common in that the final word regarding their interpretation lies with the Court of Justice of the European Union, that's the CJEU as we now call it. They are therefore endowed with a certain unity, not only of interpretation, but of function. Now, I'm not going to make any comments about Brexit and the row that's currently going around about whether we in the UK are going to be bound by CJEU decisions. That's a separate matter, but the fact is we've got this book. I think that's a long way in the future, whatever some politicians say. It's a long way in the future when the changes will take place. So we are where we are at the moment. That they have a number of other features in common means that it's appropriate, as the author explains, to treat them together, that's these instruments, as contributing different aspects to a single subject. This aim is clearly achieved with noteworthy and, dare we say, reassuring clarity, as Hartley systematically compares and comments upon the provisions of each of the three instruments based on his experience and expertise as an EU constitutional lawyer, and we're very grateful to him for giving us that information. And in the writing of the book, Hartley has aimed, quote, to present a realistic picture of the law based on the way it will be interpreted in the highest courts in the future. And that's really why I mentioned a bit about the CJEU and where we are at the moment. It's there, it's in place, and then changes will eventually occur. And if it occurs to you at this point to protest that we are leaving the EU and all of these issues are up, the response would be not yet. All these three instruments apply in the UK, remember, simply and solely because the United Kingdom is a member state of the European Union. What happens afterwards is one of a huge number of areas that we have to look at. Now, when I started writing this book, admits the author, it never crossed my mind that Britain would have left the Union so soon after it was published. But when we do leave, all three instruments will cease to be law in the UK unless, he adds rather hopefully, they remain applicable on some other basis. We are informed here that in consultations with the Ministry of Justice, the British legal profession, that's probably the English legal profession, including Scotland and Northern Ireland, has made clear to the government that it wants the three instruments to remain in force in the United Kingdom. And I would say to you, and I'm sure many of my colleagues will, that that's exactly the position that we adopt on a range of measures which have been good for Britain. The fact that we're leaving the EU doesn't mean to say we leave everything behind. We should keep those bits that are good. And I believe that is the best we can make out of this Brexit decision. Now, but whatever prevails then, it's the opinion of James Fawcett, and most would agree, I suggest, that this book will still be essential reading for lawyers in the UK, even after we've left the EU, given the preference of the profession to retain the three instruments in question. Absolutely. Most would agree too that his statement that the book will be invaluable to lawyers from other member states for many years to come is also very, very accurate as a point, because we are looking at something which is not just going to go away, and we, as I've said, we've got to keep the best bits that we can and make sure that we have some sort of cohesion and some sort of nice flowing agreements, even though we've left the main organisation. Let me conclude by saying this. For further developments on this front, check out the forthcoming electronic updates which are going to come with this book. It's also important to note that the book itself contains a wealth of research references and resources, from the extensive footnoting, the tables of cases and the legislative instruments, and a very useful, relatively short bibliography. Brexit or no Brexit then, this is a legal text that should be added to the professional library of any serious practitioner. I'm sure you'll have a copy in your own library, whether we're in the EU or just as the UK as a separate trading entity. And the law is stated, as I said, at the 1st of January 2017. It's a good book for anybody such as myself who read European law as it then was. It's changed so much in the last few decades. This book, I think, is a very great help. There's the front page again and the spine. It's not the easiest subject matter in the world, European Union law, and it's something that many people now, I believe it's still compulsory and will remain for some time, so you need to know about books like this. Here we go. Chapter 13, Choice of Court Agreements, the Obligation to Hear the Case. You see the structure, just taking one page as an example, paragraph numbering at the sides and some footnoting. So you see it's very much the house style of OUP, and I think we're very lucky to have got this book at this time, because as I've indicated, whatever one hears in the political arena, the reality is it's going to take a long time for us to sort the decision made by the British people to leave European Union, and it therefore means that books of this sort are incredibly important to all of us. So a very big thank you to everybody who's been involved in producing it. Bye bye.